So, this is the order that's outstanding. Number 5 says stairway is missing a railing. Stairway leading from driveway onto rear deck. Install handrail in accordance with Ontario Building Code. Bylaw section 6.7.1 and 6.7.2. Now, you need to understand too, this work order was only done under property standards, which raises a question because again, if it's concurrent at the same time, you have fence violations in here, so that should have been under fencing bylaw. Division, because he owns both properties and they should have been assessed together, it's division property fence bylaw. And also, they did not charge him under residential rental license because I don't think they charged anybody under that license. So they did not enforce it at all. There was no, because I guess they don't, on paper they want to make it look like, again, Shane Turner, who's responsible for the residential rental license and business licenses in Waterloo, brought in for the specific purpose based on a news report, news story when he was brought in, introducing him to who he is, the job that he did for Kitchener. And like I said, is this not amalgamation? Really? So he should have been charged under residential rental license as well. Now the other thing too, specific to this, is number 19. Chain is in state of disrepair, broken chain link fence, large gaps in fence, posts are rusting. Chain link fence dividing rear yard from neighboring property. Repair, replace, or remove under 5.5.1 B and C. The problem is that is not our fence. That is the fence of 98B, which is why, again, I think that's why they waited till the 19th to provide it. Okay, it's 3, 5, 4, 5. So where's the rest? Did I put it here? Yeah, I did. So that's 5 pages for the work order. Outstanding work order. 686 days. You're supposed to be doing it at, so let's see, 686. Now they've got it at just for the property standards by law, which is $350 per day at every part day. So even if we just did it by that, it's $240,100. 686 days just for next door. Because that railing is still not completed and that fence is not fixed. But because that fence is also not fixed and it's part of 98B, that goes times 2. Because there's 2 properties now. 2 properties that those things have not been fixed, which is their duty to do before it's even said you need to fix this. So right now, $480,200 just on the current one, if you did just the $350 a day. Okay? Then there's plus $50,000 for the first offense, for the first corporation, plus $50,000 for the first offense for the second corporation, because Mark Koenig is Atlas Property Group and Koenig Holdings, Inc. And then you have another $50,000 for Mr. Papadopoulos. That's $630,200 owing right now. Oh no, that's times 2. Sorry, that should be times 2. So that's $150,000 again, because this is 2 properties. Oh no, wait, that's why. That's the first offense. The second property is $100,000 each. So 3 corporations times $100,000 is $300,000 in potential fines. Because the second offense, every second offense and subsequent offense is up to a $100,000 fine for a corporation, times 3. $930,200 just off the cuff, based on $350 incorrectly assessed. Because the order is actually supposed to be for no less than $850 a day. So right now, based on $350 a day, as written, there's potentially over $930,200 in fines, taxes, to be collected as taxes on these 2 properties. That doesn't include operating unlawfully and everything else. There's 2 other properties that he also owns, which is 100B and 98A, both of which are not compliant either. Both of which we asked for them to all be checked out, which they should be. There you go. So that's, they keep saying they don't know where to get any taxes. We got to keep raising money. And let me ask you something. How much did the misappropriation of tax funds, how much did they spend to study this rental license bylaw? How much money did the council and everybody use in order to come up with this bylaw? Only so they can undermine it directly in the way that they do these sales contracts. Because again, it's the lawyers. It's a legal issue. Lawyers are not allowed to put legal landmines in contracts. Their whole point is to get them out of there. To make it as legal and binding as possible. They're leaving them in there because, hey, they get more work, right? They steal our value while they put the cost. We pay the cost. They never pay the cost, do they? You need to understand what's going on here. The next one, and this is the most important one. The next attachment, number 3, is copy of notice to provide proof of valid licensing within 30 days, which was sent to Ben Burley and owner-operators of Atlas Property Group Waterloo, Inc., Atlas Property Group Waterloo, Inc., Commissions Worldwide, Inc., Koenig Holdings, Inc., and Small Matters Paralegal Services, 2 pages with 7 attachments. That's this one here. It's a little small because it's a reprint of an email sent. So, regarding 2020 fraudulent application rental license, 98B Marshall Street, Ontario, sent from me from Marshall Street Association at ExecuLink, to Ben Burley, Ben at atlasproperty.com, CWW Inc. at outlook.com, Koenig Holdings, so it's really small, Koenig Holdings Inc. at gmail.com, Small Matters PA at rogers.com. Date 2020 0707 14:28 in the afternoon, priority high. So that's July 7th of 2020. Again, we waited, we demanded they hang the license. They finally did in June, at the end of June I think it was. July 7th right away, I said, I sent them this. Because they had the license up there, so we had the information available, and we said the following. So attention, Benjamin Burley, BA, Property Manager and Development Coordinator. And all I did was he sent an email here. And what I did was I used that to forward this one to him. So I used that to put it at the beginning here. So I just cut that and pasted it. And so it's Property Manager and Development Coordinator, 1 King Street North, 3rd floor, Waterloo, Ontario, Normandy Jack, 2W6, Monday to Friday, 9 a.m. to 5 p.m. And then the phone numbers, which are no longer accurate because I guess, anyway, if you want to try them, do it here. And of course, www.atlasproperty.com. Mr. Burley, and this is the important thing. This is why, because of this one mention, is what put them in legal jeopardy, I believe. Mr. Burley and the owner/operators of Atlas Property Group, Inc., which means everybody, including the CFO, who happens to be Mark Koenig of Koenig Holdings, Inc. So, Mr. Burley and the owner-operators of Atlas Property Group, Inc., and Theo Papadopoulos, owner 2576514 Ontario, Inc., operating as Commissions Worldwide, Inc. Attached, you will find a copy of a PDF file called Portfolio 1 Applicable Law.pdf, which contains an additional 7 PDF files. One is 98B Marshall Street rental license 2020.pdf is a copy of the invalid 2020 City of Waterloo Residential Rental Licensing Permit 2020 005445, issued on March 26, 2020, Class A, 4 bedrooms for 98B Marshall Street, Waterloo, Ontario, Norman 2 Jack, 2 Terrace 4, and the registered owner listed as 2576514 Ontario Inc., Commissions Worldwide Inc., your client, 455 Old Oak Drive, Waterloo, Ontario, number 2T, 2 Victor 8, and property management listed as Atlas Property Group, 1 King Street North, floor 3, Waterloo, Ontario, number 2 Jack, 2 W6, work, and info at atlasproperty.com. So that was taken directly off of the license. And I was scanned and provided in PDF format. Number 2 is Ontario Municipal Act PDF, is a copy of the applicable Ontario Municipal Acts, 2001. Number 3 attachment is Ontario ONT Building Code Reg 350.06.pdf, is a copy of the applicable Ontario Building Code Regulation 350/06. /06. Anyway, one that goes like this. I got a brain injury. I'm kind of tired right now. 4, COW underscore res hyphen rental hyphen lick bylaw PDF is a copy of applicable City of Waterloo Residential Licensing Bylaw 2011047. Attachment 5, COW Property Standards PDF is a copy of the applicable City of Waterloo Property Standards Bylaw 2011122. 6, Fence Bylaw PDF is a copy of the applicable City of Waterloo Fencing Bylaw 2013-017. Number 7, COW Division Fence Bylaw PDF is a copy of the applicable City of Waterloo Division Fence Bylaw 09-009. So basically I sent them the applicable law. The reason this package has been sent to you is as legal notification of your responsibilities as owner, landlord, property management, which operates in the province of Ontario and in the City of Waterloo, so that there are no more excuses to claim you are unaware of the legal requirements to have and to maintain a lawful rental, as defined by the law, at every one of the properties owned or managed or maintained by both companies listed within the province of Ontario or City of Waterloo specifically. This now applies to every property you own or manage within the applicable area of the City of Waterloo in the province of Ontario. We are making a public declaration of the fact that you have been provided a copy of these resources, so every one of your properties is now open for review by the tenants of Waterloo in Ontario. This was sent July 7th, 2020. In answer to them finally posting the license here, because again, they knew what I would do as soon as I found it, when they confirmed that they had it. And that was before I realized they're misrepresenting the facts as much as they are. Distraction and brain injury and stress and heart problems and all that. And effectively being removed from the ability to get health care or any help from anyone. And we invite you to go see the series, please. It's all there. We're just presenting the information. It's there for you to make up your own mind. We just did what we thought was right in order to preserve the facts and preserve the way that they chose to do this, and the possibility that if they did not do what they were required to, I at least knew enough to hit every point to make sure that I covered the bases on behalf of all taxpayers, law-abiding citizens, at least as far as I know. And I'm not a lawyer. I don't profess to be. I'm just reading what's there and doing what's necessary. It worked when I won custody. That's what rules are for, not to be bent. Okay, where am I? We are aware of several inconsistencies at 98B Marshall Street, Waterloo, Ontario, Norman 2 Jack, 2 Terrace 4, which demonstrates a fraudulent and misleading application and acquisition of this license, which indicates that false and misleading information as provided in the application, which, given the current law, says the City of Waterloo 2020 residential rental license for 98B Marshall Street is invalid and fraudulent. As the licensing applicants, we have made you aware of your legal obligations and civil liability due to gross negligence and possible municipal act fraud. As such, we invite you to immediately provide within 30 days a complete home inspection of 98B Marshall Street in Waterloo, Ontario, Norman 2 Jack 2 Terrence 4, and provide it as proof of valid licensing of this property. You are also both invited to assess and correct any and all deficiencies to bring this property into lawful compliance. You are responsible for all damages. Govern yourself properly. Sincerely and without reservation, Chris Bacon, Director Representative for Marshall Street Tenant Association, on behalf of Kerry Mills, Tenant Leaseholder, Marshall Street Tenant Association member. 30 days would have been July 7th, 2020. This was sent to all parties that are all part of this action right here and right now. The ones that have misrepresented all documents before, well, they misrepresented these applications. And again, it's a simple fix. Every one of you, and I say municipal act, landlord-tenant, are acting on the fact that you are saying that this is a lawful tenancy of good standing. This license is valid. There is no problem here. And you are using that as the basis to not only collect unlawful rent, what we claim is unlawful rent, but also to evict us because you don't want to pick up the check. And you make it up as you go along, you manipulate the system. It's a simple answer. Do the inspections because one of us is lying. Or I should say, more correctly, one of us is not lying because everybody else is. Anyway, as I said, page 2 is it goes P.S. There's a problem with the HVAC assessment too, and fire, etc. Good luck. And then this is because I forwarded, because on February 12th, 2020 at 4:12, Ben Burley wrote, "Hey Kerry, this is notifying you that we will be entering your unit on Friday, February 14th, 2020 to perform an HVAC inspection. Technician will be arriving between 12 p.m. and 2 p.m. A representative from Atlas will be present for the inspection. Thanks, Benjamin Burley." And he signed it like that. So that's why I just cut and pasted that, because that's who I didn't know who he was. I just cut and pasted that, put it here. See? But I also was smart enough to use it as a response, RSVP from this one, because the other thing too is, at that time, Benjamin Burley and Atlas were all told that I was the only representative they were to talk to because of what they were doing. This was just a continuation of what they did at 98 and 100A. You know, exactly the same thing in the harassment of it. Anyway, so this is the letter. This is why Atlas Property Group is now permanently closed. And this applies. This is a document that is legal standing. Because if it didn't, why'd they close? Either way, the question is for the ministry and the city to answer, especially in context of a judicial, like a judge review and a commissioner's review, and a criminal investigation, because again, if they, anyway, I'm not going to tell you how to do your job, we're just raising the alarm. Either way, this eviction needs to stop right away, and either way, well, no, go ahead. But either way, before anything else happens, we need to know the lawful legal standing of this structure as of this date and time. And that's not us, that's the when I say us, I mean the taxpayer. That's who you owe. And it's already bought and paid for in the services. Something that is $450 that we should be able to go and get. We could have paid $450 a long time ago at either one of these properties and brought it anywhere and said, there's your answer. The only reason why we are prevented from doing that is because the people that are responsible is not the landlord and owner or property management. They're the ones who get the cost if they're caught. But the ones who are ultimately responsible to make sure that it is minimum code is the Ministry of Municipal Affairs and Housing, period. Starts with you. The law is set up that if it's not done by the landlord, you do it. The vehicle is there for you to not impede, and everything is set to not impede with the tenancy or the occupants. Least amount of hardship, because onus is on you and the people who are claiming this is of code. It's time to prove it, because we are proving that it's not. And if you're not here to do it, live on YouTube, everybody. We will go step by step. Because the joke is this. What happens when they try and say that a brain injured guy, they didn't know that I had run a co-op for 2 years as the president? Where number one thing that we dealt with, and now that I've done my research, probably with Shane Turner at the wheel in Kitchener, we've dealt with this before. So lesson to be learned, don't think brain injury means stupidity. And know thy enemy. Sun Tzu, right? Anyway, you're finding out, aren't you? This is for no improper purpose, which is why I'm acting on behalf of all in this, especially other tenants. And let me say that if there's a tenant, you've been in City of Waterloo, rental, other than there are some buildings that are not applicable, and every one of these new buildings going up, everybody needs to realize they're not rent control. None of these new buildings going up that they're spurting up like weeds, it's because they're contract to build. The same way they did the RIM, the same way they did 407, the same way they did the Mississauga boondoggle with the hydro or whatever the hell it was, or wherever it was out there. All different governments, NDP, conservative, and liberal, because that's the distraction. It's about the ways and means, which is banking and municipal act and the judicial system as a system of containment, also run by the state, also known as a prison. Anyway, the last attachment, thank you for being patient. I'm sorry, this has been very trying, and I'm taking one for the team. It's time for the team to step up, please. Number 4 and final attachment, copy of notice of misrepresentation, malfeasance, misfeasance, and fraud sent to Commissions Worldwide, Inc. and Atlas Property Group, Waterloo, Inc. and Koenig Holdings, Inc. and Small Matters Paralegal Services, 3 pages with 1 attachment. Dated Friday, May 7th, 2021. Sent by registered mail. Signature required. Commissions Worldwide, Inc., Atlas Property Group, Waterloo, Koenig Holdings, Inc., care of Small Matters Paralegal, 139 Horseshoe Crescent, Breslau, Ontario, Norman 0B, Norman 0 Beta, 1 Motel 0. Okay? Dated Friday, May 7th. Sent by registered mail. Attention, Lisa Nadon, paralegal representative, Law Society of Upper Canada, number P as in Peter, 00925. Anybody else who feels this is wrong and wants to make a complaint, please, I encourage it. And this is notice to the Law Society of Upper Canada that this is my official complaint as a person with a disability under AOTA, because I'm not able to write it down, and I've done it already, and this is it, baby. Consider this blanket notice, Premier and Attorney General and everybody, because you're in trouble. And I do this on behalf of all taxpayers. Anybody who feels they've been treated notwithstanding, especially when it comes to rent, or being assaulted by police in the Waterloo region. Anyway, sorry. In the matter of the collection of unlawful rent and maintaining a rental business contrary to the rental license and law, in a claim of active participation in direct managing and ongoing malfeasance, misfeasance by Commissions Worldwide, Inc. owner, Atlas Property Group, Waterloo Property Management, and Koenig Holdings Property Management, and Small Matters Paralegal, and others. Matters of misrepresentation regarding City of Waterloo Residential Rental License Permit number 20200054445 and ongoing harm and damages. Regarding interim order received May 6, 2021, Tribunals Ontario LTB file number SWL 46391-20 on behalf of Commissions Worldwide, Inc. N5 notice dated the 31st of December 20 regarding harassing behavior, illegal structure on behalf of Commissions Worldwide, Inc. Tribunals Ontario LTB file number SWL 4194820 on behalf of Atlas Property Group, Waterloo. That's the one from November that they canceled, even though they accepted our evidence. And that's because they were quietly letting them go out of business, I guess? Well, I don't know. That's for the judge and the commissioner to find out, and the police, I guess, right? Especially how when it's sent by mail by the landlord-tenant board directly to the person who is having the hearing, how mail disappeared. That is a crime. If they sent it by mail, we are reporting that we never received any mail from landlord-tenant board with regard to certain hearings. You can get in touch with us. We'll be specific as to which ones. It's in the record anyway. Including the last one, where they have this unlawful order. Anyway, continued harassment and abuse of disability rights and human rights, possible criminal fraud seeking full investigation, outstanding work order and other ongoing maintenance issues, possible civil tort action for misfeasance and damages and costs, referral to Law Society of Upper Canada and other governing bodies for a full review of this case. This is legal notice sent May 7th of this year. Ms. Nadon, I hope this letter finds you well, and hope all is well with you and yours in this stressful time of COVID lockdown. Firstly, with respect to the interim order just received on May 6, 2021, please find enclosed the Bank of Montreal draft 907-207 dated August 4, 2020 in the full amount of $1,200 payable to Commissions Worldwide, Inc., which is for the month of May 2021 as directed. And that's what page 4 is. See, page 4, that is a photocopy of the actual money order. Sent in good faith, payable for May 2021, which was held over from last year. It was originally for last year's rent, but they didn't come pick it up because they were claiming we didn't pay our rent. Because it's unlawful to. It's unlawful to cause it to be collected or to pay it or to cause it to whatever. So we weren't going to break the law by paying it. We said, here it is. It's sitting on our fridge. They're coming by supposedly for maintenance and stuff anyway. So, and they had done it before where we had it on the fridge. They came and they picked it up and they took it with them. For several months before they stopped doing that. And the reason why they stopped doing that is because we pointed out it was unlawful to do it. So that's how they created this so-called situation of unpaid rent, when it's unlawful to pay it in the first place. And the only way we get an answer is, how's that happen, Steve Clark? Doug Ford, any clue? Can you help us out here? Why don't you go talk to the Ministry of Transportation, see how they utilize their resources to get it done properly for how you license something properly and more efficiently. They can do it. Must be some big secret, eh? Intergovernmental secret. Hey, there's that guy for intergovernmental affairs. Maybe you guys can get together over coffee or something. We'll pay for it. We don't have any choice. Everybody pays for it in the end. Like I said, they take the value. We pay the cost. At our own expense. This is to honor our part of the unlawful interim order as an act of good faith on our part in this ongoing matter. This payment was originally for August rent, which you were notified of and failed to collect, even though it had been ready to collect since the 4th of August 2020, but has now been repurposed to meet the requirements of the current order with regard to ongoing rent from May 1st, 2021. The total amount Ms. Mills claimed for collection of unlawful rent collected to date at 98B Marshall Street, Waterloo, Ontario is now in the amount of $44,400. Then I wrote it out like you do a check, $44,400. As of this date, we strongly urge you to cease and desist this unlawful behavior and to return all monies unlawfully collected and received immediately, and to cease and desist any further action in this matter that is punitive and harassing, and to bring this property into compliance. Your clients have not honored the terms of the rental lease entered into since July of 2017 and are acting criminally, to wit, we intend to seek full criminal investigation. This is now a human rights matter as well. We expect it will require an equal act of faith and are asking for a full inspection of this property by the Ministry of Municipal Affairs and Housing, Municipal Enforcement, to determine the proper current legal standing of this property, so that the claims of both parties can be examined unbiased and based on the facts. One of us is misrepresenting our position, and this is the only fair and equitable way to make a proper and legal determination going forward. We also believe that the outstanding work order proved this property has never been to code, especially given the history of repairs and management with regard to Mr. Koenig and his history across multiple properties.